Hi, everyone. Welcome to ComMaciel Carey's first in its annual webinar series for the labor and employment practice. And this webinar is going to be covering insights into wage and hour investigations. We're glad you could join us today. I'll introduce myself first. My name is Lindsay DeSalvo, and I am a partner at ComMaciel Carey in both the workplace safety and labor and employment practice. My background as related to the topic we're covering today, I have done a lot of work with clients reviewing pay practices, helping audit employee classifications or worker classifications as exempt employees and independent contractors. I've represented employers in litigations brought on both an individual and collective basis related to allegations under the Fair Labor Standards Act or FLSA. And I've also helped advise employers in the course of wage and hour investigations, which is our topic for today. And I will kick it over to my colleague Scott to introduce himself.
Thanks, Lindsay. Glad to be here with everybody today talking about wage and hour issues. I'm also in Con Maciel's DC office and also in both the workplace safety and labor and employment groups. My background is in both wage and hour and OSHA and MSHA investigations, including time spent with the Department of Labor, more than a decade there, almost 12 years, in various roles, both doing trial work in both regional offices and the national office, as well as spending time within the wage and hour division in a strategic planning role. So have knowledge of these on both sides of the V, and interested to chat more about it today with you all. Lindsay, I don't know if I'll just go through the agenda real quick and then kick it over to you to start with the substance. But we'll be speaking today about the enforcement priorities and concerns associated with the Trump administration in the second year of Trump's second term. We'll talk generally, provide an overview of how wage and hour investigations proceed. And finally, we'll talk about some best practices employers can implement to address investigations if they occur, or even to try and take proactive steps to prevent and sort of mitigate risks from potential wage hour investigations. So with that, I will kick it over to Lindsay to start the substantive portion of our program.
Thanks, Scott. So before we jump into sort of the bulk of our presentation today, what to expect during a wage and hour investigation, we wanted to take some time to go through what we've seen as priorities of the current administration and sort of how they're looking at these various issues, but also topics that we've seen come up in the course of wage and hour investigations. What are the major things that the wage and hour division is tending to review during the course of a wage and hour investigation? What are the issues that most commonly come up? And one of the areas that we've seen wage and hour delve into the course of an investigation, and also an area that's been a priority of and had differing interpretations based on administrations, is the treatment of independent contractors. So, in the Fair Labor Standards Act, there is no definition for an independent contractor. But if a worker is classified as an independent contractor, they are able to be treated differently than an employee of that particular employer. And where that's significant often is in determining pay and whether they would be eligible for overtime. They are as an employee and they are not as an independent contractor. Because of the fact that the law doesn't provide a definition of independent contractor, there are varying structures that are used in evaluating whether an employee or whether a worker is considered an employee or an independent contractor. Courts, the Department of Labor, specifically the Wage and Hour Division, the IRS, NLRB, all of their standards for independent contractor and evaluating independent contractor status are a little different. But generally, what they have in common is that they all tend to consider the economic reality of an independent contractor versus an employee. And generally, in the context of an independent contractor, that they are economically independent. They are not dependent on the company from an economic perspective, and sort of different elements within that broad standard for who would be considered an independent contractor. The standard for an independent contractor was actually promulgated during the first Trump administration, where the Department of Labor decided to promulgate a rule that would provide sort of a standard to be used going forward for determining whether a worker is an independent contractor or an employee. And that particular standard highlighted two core factors that would be considered by the wage and hour division in evaluating whether someone should be considered an independent contractor or an employee, as well as, companies that they would have to look at these factors as well in determining who they classify as an independent contractor or an employee. And those two core factors per the 2021 independent contractor rule was the nature and degree of control over the work, who sets expectations for how the work is performed, when the work is performed, the tools used for the work to be performed, who is setting those expectations? Is it the worker or is it the company? And that was one of the core factors that would be considered per the 2021 rule, as well as the individual's opportunity for profit or loss. So, does the worker have the ability, depending on the way they work, to suffer economic loss or benefit from economic gain in the way they perform their job? And those were the two core factors per the 2021 rule. And then there were also three sort of supporting factors that would be considered. But the two core factors identified in the 2021 rule would have been sort of the main things that the wage and hour division, in the course of an investigation, would be looking at and evaluating independent contractor status. That rule was ultimately rescinded in 2024 and replaced by another rule defining independent contractors and how you would determine whether someone is an independent contractor or an employee. And that rule that went into effect in 2024 brought back the six elements that are considered part of the economic realities test, which is what the wage and hour division had been previously using prior to 2021. It brought those six factors back that would all be weighed together in determining whether someone is an independent contractor or an employee. That rule, importantly, has been the basis of multiple legal challenges, which are ongoing. And the administration actually put out guidance last year that they would not be enforcing the 2024 independent contractor rule, and that they intend to rescind it, though they have not done so yet. So, in thinking about the treatment of independent contractors and how the wage and hour division might look at this if they do come in and conduct an investigation that addresses this particular issue, the wage and hour division, like I said, did put out guidance last year in May of 2025 to set expectations for what they would do in the interim. Like I said, they have not promulgated a rule to replace the 2024 rule yet, but that is something that they are still considering. That does seem likely at some point, that they haven't taken the steps yet. And they issued what's called a Field Assistance Bulletin, or FAB. And in that Field Assistance Bulletin, they addressed the fact that they would not be enforcing using the 2024 independent contractor rule, that they did plan to likely rescind and replace it. And then they also referred back to previous guidance that had been in effect prior to both rules that have been promulgated in 2021, and then the one that replaced it in 2024, that the wage and hour division would rely on in evaluating whether someone is an independent contractor or an employee. And it pointed back to a wage and hour division fact sheet from July of 2008, as well as a prior opinion letter that sort of discusses the factors and how the wage and hour division would sort of weigh those factors that are provided in that fact sheet number 13. And that fact sheet generally lays out the six elements that the like I said, the wage and hour division had been using prior to the 2021 rule. And those are the things that will be weighed by the wage and hour division. But, importantly, that 2021 rule that looked at the two core factors was passed during the prior Trump administration. So we think there's a good chance that something similar could be put forward in this administration to replace the 2024 rule. And certainly, in the course of an investigation, those two core factors, we know that those have been a priority for the Trump administration's Department of Labor in the past. So, those certainly could weigh heavily in any investigation and evaluation of workers, in the current administration. The next big issue that is often evaluated in the course of a wage and hour investigation and has also been a priority of the Department of Labor for the last, I would say, at least around 8 to 10 years. There's been some action on sort of the standard for classifying exempt employees, particularly the salary threshold for doing so. Um, but that is a big issue as well. The classification of employees as either exempt or non-exempt. Under the Fair Labor Standards Act, if an employee is classified as an exempt employee, that means that they are not entitled to overtime. They're paid on a salary basis, and they are paid that salary no matter the hours that they work. But there are only certain types of employees that can be classified as exempt. And the Fair Labor Standards Act and its regulations lay out what those particular positions are that can be considered exempt. And those are your administrative, professional, executive. Those are sort of the main classifications of employees who are considered exempt. And then there are a couple other exemptions as well, like the computer exemption that employees can fall into depending on whether they meet the three elements to determine an exemption. And these are the three elements to determine whether an employee can fall into one of the exemptions. It's the job duties, salary basis, and salary level. I'll address the second two first because they're a little bit easier. Salary basis just means that the employee is paid on a salary basis. Again, uh, it doesn't matter the hours that they work, they're going to earn the same pay. And then they have to be paid a certain amount to be able to be considered exempt. And that's where the salary level threshold comes in. The salary level threshold, like I said, is the main point of exemptions that has kind of gone back and forth based on the different administrations over the past several administrations. Um, it was, sort of first promulgated that there was a change in the salary level threshold during the Obama administration. That changed again during the Trump administration. And there were efforts to do so again during the Biden administration, though it has gone back to what was established during the first Trump administration, which is a salary level threshold of $684 per week or about $35,568 per year. So any employee that's classified as exempt has to be paid at least that salary threshold level. And then the third element here is the job duties. This tends to be the more complicated piece of determining whether an employee meets one of the exemptions because there are primary job duties that they have to perform in each of the exemptions that are provided in the Fair Labor Standards Act. And sort of doing an analysis of that is what can be challenging for employers. And then certainly in the course of a wage and hour investigation, they're going to be looking at, okay, the employees who are classified as exempt, are they actually performing those duties they need to perform to be in that exemption? Are they spending the amount of time in those duties that they need to spend to meet that exemption? And really carefully looking at that both in the manner of reviewing job descriptions for those positions, as well as likely speaking to those employees and, determining exactly what they do in their position. Another issue that comes up often in the course of wage and hour investigations is, has overtime pay been have employees been compensated properly for overtime? And the area that we see as an issue quite often is what an employer is using to determine overtime pay. So if employees do work, if they are non-exempt and they work over 40 hours per week, are they getting paid overtime and are they being paid at the proper rate for overtime? A common wage and hour concern that does come up is, are they being paid at their regular rate of pay? So oftentimes employees who are classified as non-exempt have an hourly rate that they earn, but overtime is based on the regular rate of pay, which is not necessarily their hourly rate. The regular rate of pay also factors in other forms of compensation that the law requires to be included within the regular rate of pay. One of those types of compensation is non-discretionary earnings or non-discretionary bonuses, where certain factors are set that if met, the employee gets that bonus. So it's not discretionary. There's no sort of leeway and whether they get it as long as they meet the factors to get it. And those types of additional payments also have to be included in a regular rate of pay to determine proper overtime. And this is something that the Wage and Hour Division will delve into closely in examining pay records and evaluating total compensation that employees have, what should be included in the regular rate of pay based on how those other forms of compensation are given. Um, you know, Non-discretionary earnings have to be included in the regular rate of pay, but discretionary bonuses, things that are sort of dependent on the decision maker to decide whether to provide them, they're not sort of automatic. Those types of earnings are not included in the regular rate of pay. So those are the types of things that the Wage and Hour Division would look at if they were conducting an investigation and determining whether an employee has been paid properly, and specifically whether they've been paid the proper overtime rate. A fourth area that we see come up quite often, and that has also been a priority for the Department of Labor in the past, is the treatment of tipped employees. And this won't apply to all employers. It only applies to employers that have tipped employees, often, restaurants, hotels, those in the hospitality industry. That's where we see this come up most often. But if the Wage and Hour Division does decide to investigate someone with tipped employees, it is very likely that they're going to be taking a close look at how those tipped employees are paid. So under the Fair Labor Standards Act, anyone who customarily receives more than $30 per month in tips for services to customers can be considered a tipped employee. And if they are considered a tipped employee, there is the ability for the employer to pay a certain amount of a cash wage, so direct pay to the employee, because of the fact that the rest of their compensation will be made up in tips. And the current federal standard for, and this can be very different from state to state and even counties or cities within states, but the federal standard for tipped employees and employers who take a tipped credit is that the required cash wage is $2.13, and the tip credit can be $5 and up to $5.12, or it has to be at least $5.12 to make sure that they are making the full minimum wage of $7.25. An employer can only take a tip credit, even if the employee meets the definition in certain circumstances. They have to provide proper notice to employees, and they have to be sure that the time for which they're taking a tip credit is when the employee is performing tipped and non-tipped work that qualifies for the tip credit. So not all work that an employee might perform might fall into that category of the employer being able to take a tip credit. So it is something that an employer has to closely follow and document, and that is something that the wage and hour division is likely to look at closely and evaluate, determining whether tipped employees are being paid properly. One more quick note related to tips and the ability to take a tip credit. This is another issue that the Department of Labor in the past, during the Biden administration, did try to promulgate a rule, which we call the 80-20-30 rule, which sort of established specific qualifications for the time that employers could take a tip credit. And it was any time spent performing non-tip producing work, the employers would be prohibited from taking a tip credit for any time spent performing non-tip producing work where that work constituted over 20% of the employee's work week or where it was being done for 30 or more consecutive minutes. So that was the rule that was promulgated during the Biden administration. It was actually vacated by the Fifth Circuit back in 2024. So it is not currently the applicable rule. And it was going to be quite a challenging rule for employers to actually implement, to sort of have to take that time of calculating this 20% or 30 or more consecutive minutes. So it was ultimately vacated by the Fifth Circuit, and the Department of Labor, following that, did rescind the rule as well and reinstituted the prior dual jobs language that had been in place prior, which gives employers a greater ability to claim time for tip credit than would have been the case under the rule promulgated by the Biden administration. And then finally, another good way to sort of be aware of the types of issues that the Wage and Hour Division might be looking at in the course of an investigation, as well as the focus areas and priorities of the current administration, is guidance that's being put out by the Department of Labor, particularly the Wage and Hour Division. Uh, as some of you or many of you might know, depending on how closely you're sort of following information provided by the administration, compliance assistance is a big priority of the current administration, and they've put out press releases, news releases, sort of emphasizing the fact that they are looking for people to ask questions. They will respond in letters of interpretation to provide additional guidance to anyone affected by these rules as to how the Fair Labor Standards Act and the regulations implementing the Fair Labor Standards Act apply. Recently, they did have a few letters of interpretation that they put out in the beginning of the year, two of which specifically addressed some of the issues that we talked about today in the course of this webinar. One of them reemphasized the requirements for the professional exemption, as well as the fact that the employer must actually claim an exemption. So an exemption is not automatic. Even if an employee meets the requirements of an exemption, if an employer hasn't claimed the exemption, that's their decision. So they do have to take that step of actually claiming the exemption. Um, and then they had another recent letter of interpretation talking about this idea of non-discretionary bonuses and how they factor into, that regular rate of pay calculation and the overtime rate. So those are just some examples of recent letters of interpretation that highlight some of these priorities, highlight how the Wage and Hour Division intends to evaluate these issues. So again, the guidance is really important as well as you're preparing potentially for a wage and hour investigation or you're in the midst of a wage and hour investigation. These guidance documents from the Department of Labor and the Wage and Hour Division really tell you or can tell you a lot about how they're going to look at a particular issue and what you can expect if they're evaluating pay practices at your facility. And so guidance is a good indicator of their priorities and of how they expect employers to comply with the law. And it is also really helpful to just be aware of so that you can address some of these concerns in advance of a potential investigation. And Scott, I will turn it over to you to talk a little bit more about that.
All right. Thank you, Lindsay. Just to plug, excuse me, I was going to say plug our blog, and I said plug. Just to plug our Employer Defense Report blog, it has additional information about the recent opinion letters that Lindsay was just referencing. Goes into a few more that were promulgated on January 5th. They were the first batch signed by the Wage and Hour Administrator Andrew Rogers, who was confirmed during the government shutdown. So certainly now that there's a political leader confirmed in that administrator spot, we can expect potentially to see more on crystallizing what the priorities of the administration. As Lindsay said, we're going to start talking a little bit about the stages of a wage and hour investigation, um, including sort of the life cycle of that investigation. Typically, begins with an opening conference, where, from the beginning, you certainly want to seek clarity and work with the Wage and Hour Division to narrow the investigation scope to the extent possible. And to do that, you'll want to ask questions about what the needs and the intent and the purpose of the investigation are, and manage the investigators' expectations. A focus on, really what does wage and hour. Again, you want to seek to basically narrow the scope of the investigation reasonably, and determine what wage and hour really needs to resolve its investigation. You'll then likely need to provide records and other information. You want to keep a copy of those, of course, and you only want to share. This goes again to narrowing your request, narrowing the scope of the investigation. Only share information that is responsive to wage and hours requests. You don't want to overshare. You don't want to share things that are outside the scope of the investigation or outside the scope of the requests, because then you're just providing more than is needed, and you're potentially opening doors and increasing potential exposure under the investigation. You want to coordinate the investigator's activities, including managing interviews. Of course, an investigation is going to be disruptive to some degree, but they're not supposed to be, overly disruptive to your business activities. So, work with the investigator to the extent possible to schedule, reasonably when he or she might visit, or they might visit, when, responses to requests are due. Often, Wage and Hour may put a request limit based on a reg that says if if materials are stored off-site, you need to produce within 72 hours. That also suggests that if they're on site, you need to respond immediately, which is not going to be reasonable. And typically, we've had good success working with investigators to ensure that they allow reasonable time. The best way to do that is really to try and develop a rapport with the investigator. Be cordial and professional, but also, protect your rights by limiting disruption to the business operations. Um, and as you coordinate the investigators' activity and you accompany them during any on-site, be aware of what they're asking and who they're asking to speak to, and what kind of notes they're taking. You want to know what their priorities are, and this is another way to really understand the purpose and to keep your responses and your participation in the investigation as focused as possible. There are ways, along the way, if you've developed that rapport, to sort of check in and kind of figure out where the investigation is. Lock in if something has been sort of eliminated as a potential risk or a potential violation. Double check, say, hey, I know you talked to this person. Sounds like that's all set, right? That's off the table. tactfully, but you can lock that in a way that hopefully continues to sort of winnow down what's at issue and what's on the table during the investigation. It's important to kind of keep that conversation and that communication going. And again, to do the best you can to keep it limited and as not disruptive as possible. At the end of the investigation, following document review, following employee interviews, there should be a closing conference where the investigator will confirm the closure of the investigation, including whether there were violations found and whether you may need to provide payment of back wages or other civil money penalties. We've found that at times wage and hour tends to um, put the civil money penalties sort of at the end or even after you might have settled a proceeding. Be careful to be on top of that and ensure that you're raising that issue. You want to make sure that you're truly resolving the full case. Investigators will typically disclaim responsibility for civil money penalties, and they'll say, "Oh, that's up to my supervisor or someone sort of higher up the wage and hour chain." But be aware if there's the potential for CMPs that if you are trying to resolve a case and you're settling with a particular financial number in mind, that is what you are able to spend and what is justified for you to spend, make sure that CMPs aren't going to hit you after the fact. You just want to stay on top of that issue and make sure you're aware of their potential or not. That's another thing to connect along the way and see whether you're able to eliminate the possibility of civil money penalties. So digging into some of the issues here, an investigation can start basically through two avenues typically, and that would be in response to a complaint from an employee or former employee, or through case selection based on agency priorities. And that was when I was within the wage and hour division as the acting director of strategic planning and performance. That was a big part of my role, determining what our enforcement priorities were, working with my team to do that, and figuring out how we would select cases in areas of priority. So that is something that's considered by the government and where they're going to go in a given fiscal year, and is a way to for them to determine where an investigation may open. But one thing you should be aware of is that they're not likely to advise you of how an investigation started, whether it's because of an emphasis program or because of a complaint. And certainly, if it's a complaint, they're not going to tell you who complained. They want to avoid any sort of potential for retaliation to the extent possible. So they're not going to identify the sort of squeaky wheel there. Wage and hour can show up to your workplace unannounced to perform an investigation, but typically we see appointment letters, which basically suggest a time for a meeting on site and also provide a deadline to make the documents requested by Wage and Hour in its investigation available. And again, here's a time where you might see a 72-hour notice. You need to produce these as within 72 hours based on regulatory authority that the department has to conduct its investigations. But if you're able to sort of reasonably work and provide a reasonable extended period to produce those materials, that's probably best to allow you to get a handle on things and potentially bring in competent counsel if you need support. But it's important to respond to that letter promptly. It can set the tone for the investigation, including garnering that extension and making sure you're able to tackle that. Hey, Lindsay, did you have something to add?
Yeah, I just wanted to add, talking about sort of the responsiveness, and you already kind of referenced this on the prior slide related to document production. But, I think you're you're trying to weigh here your ability to respond promptly with also making sure that you're carefully reviewing everything that you're considering providing. Because, like Scott said, you want to limit to specifically what was asked for. And this does come up sometimes where there could be documentation that's sort of overlapping, potentially responsive, but addresses other issues. And we want to be really careful and cognizant of that because you don't want to open the door to them expanding, right? They are here looking for something specific, looking for specific records, a particular issue that they're trying to evaluate. And if records are accidentally provided that show some other concern or raise some other red flag for them, then they have a basis to expand the scope of their inspection. And so it is really important to take the time to carefully evaluate that documentation before it goes out. And that's something that can be negotiated, a reasonable time period in which to sort of accomplish that, or sending some documents a little bit sooner that you've been able to verify, wait on others, take a little more time with those. And then also really ensuring that during the production process, you're tracking what's being produced. Because you want to have a full understanding of what's been given to the wage and hour investigator, what they're looking at in the course of the investigation, for multiple reasons, one of which being at the closing, is there a basis for, the potential violations that they're highlighting? Is there an opportunity to sort of talk about those based on the documents that were provided? But also, certainly, if violations are issued and we're going to go, into trying to resolve those violations, having for yourself and potentially counsel, if you choose to bring them in at that point, a full record and tracking system for everything that was provided to the Department of Labor, to the wage and hour investigator, is really important.
Yeah, absolutely. And I think you made me think about the fact that you may get these requests that are asking for 2 or 3 years of payroll records, right? Standard is 2 years. If there's some indication of willfulness, wage and hour may ask for three, but something to be thinking about is whether that is, again, something wage and hour needs. I mean, if you have compliant practices, why not suggest, hey, we can provide you the last 2 weeks, or we can provide you two payroll runs from this date and this date so you can see that we've been in good shape for a period of time without pulling all those records. And I did keep saying, reasonable extension. And what I mean by that is, you're not like, yeah, we got your letter that wants stuff in 3 days. We'll get it back to you in 8 months. But consider, what will allow you to make a production, even if it's the initial, tranche of a rolling production within a period of time that is both reasonably responsive to the government, but also feasible for you. Because you don't want to continue going back and saying, oh, we actually need more time. Oh, we just figured out this other stuff is over here and this person left and that person is on vacation. You really need to consider those things to the extent you can up front so that you aren't kind of going back to the well over and over. That's just going to sort of probably make the wage and hour investigator question whether you're really making an effort here. And I'm not suggesting this isn't difficult at times, and especially if they ask you overbroad questions, which is one reason that you really do want to narrow and work with them to say, what do you really need? Um, but, to keep going back to the well on extensions can also just disrupt your relationship where you want to keep that professional and cordial relationship, and collaborate to bring this thing to a conclusion. Because as we like to explain, we're both on the same side wanting to resolve this thing as promptly as and efficiently as possible. Everyone has that goal. Nobody wants this to linger forever. So, how do we work together to make that happen? It's important to think about that, from the very start of the investigation. So we also wanted to speak a bit about interviews. Interviews are certainly a big piece of an investigation. Wage and hour is going to want to talk to people. They're going to want to ask what their job duties are, as Lindsay spoke to about sort of exemptions, or independent contractor versus employee status. They're going to want to know on the ground, what are these people doing? What are their responsibilities? What are their primary duties? What are their salaries? What kind of training do they have? Do you have the required posters available so that folks know their rights? Do you have a way for people to bring complaints to your attention internally before they feel that they need to go outside and potentially contact DOL? So in that interview space, though, Wage and Hour can request privacy for sort of line employee, hourly employee interviews. They can take written notes. They may ask to record the interview. They may ask the employee to write or sign a statement. And they can ask questions about documents that, they have, or, I would suggest on all of those, the employees are really in the driver's seat because they're the ones with the information. They should respond to questions from the Wage and Hour Division truthfully and accurately to the best of their personal knowledge. It's not about guessing or speculating. You want, again, just as you're responding to the questions with concision and answering the question asked in responding to document requests, the same is true for folks speaking with Wage and Hour. They want to listen carefully to the answer, or excuse me, to the question that's asked and answer just that question. Employers on the other side should not be, coercing or coaching or pressuring employees about whether to speak with the investigator at all, or certainly about how to respond. While the Wage and Hour Division can ask for privacy with hourly employees, and we say with hourly employees because you have a right to have counsel in meetings with management, because management can make statements that bind the company, and therefore company counsel can be in those meetings. But typically, with line or hourly employee folks, you don't have that same right to counsel. However, an employee, interviewee, does have the right to request someone be present, a friend, a coworker, their supervisor, company counsel, whoever. And so that's an option that and a right that should really be explained to the employee prior to their participation in an interview. It is their right to participate at all in the interview or to end it or not answer particular questions. They may be subpoenaed later, but at the initial stages, it's a voluntary process. We talked about, the investigator could ask about documents, and we'd suggest not answering questions about a specific document unless you're looking at it. So the employee should be able to look at a copy of a particular training or a pay stub or whatever the question concerns. And then, we would suggest that employees don't sign anything that they don't agree with or that they haven't had the opportunity to read and correct. Certainly, if you're going to sign your name to something, you want to make sure it's accurate. It reflects what you told the investigator. And so consider whether to do that, to submit a signed statement at all. And certainly, if you decide, okay, I'm going to sign something, make sure it's correct. And you'll see on the slide here, the big block, never retaliate against an employee for participating in an interview, right? That's a protected activity. And it's better. We always say that I think it's better to deal with the truth and have that employee provide the facts and let the facts come out so that we can address them than it is, to be surprised or certainly to have it come out that you coerced a response or coached an employee on how to say things, because then you will wind up with a 3-year request because you'll probably get some sort of there'll probably be some suggestion of willfulness potentially in the practices that are being investigated if you're trying to control the employee, and you don't want a retaliation claim added to any investigation. So, considering what kind of information you might get at the closing conference, again, Wage and Hour is not going to tell you how the investigation started, but they will communicate to you what their findings were based on the evidence they gathered during the investigation, excuse me. It's important when you sit down with them to listen carefully and understand what the findings are, confirm what they are. Avoid, admitting anything initially or making promises, but request time instead. Request time to consider and be able to respond thoughtfully to those allegations. There are many paths you can walk after the conference. Next steps could include just accepting and paying whatever the proposed amount was. That may not be your best bet. Everybody makes mistakes. The wage and hour software that does calculations is dated to say the least. It's called Wizard, which is somewhat hilarious because it's far from magic. But you do want to be able to review those back wage calculations and review what all went into them to say, hey, I think we provided some documents that counteract this alleged recovery amount. Um, you can address an option, your best option, in fact, might be to address disputes and negotiate settlement with wage and hour after they've made their initial findings. Say, hey, let's talk this through. We think there's some discrepancies in the violations and the amounts of back wages you're alleging. Let's talk through it and see if we can, bring those numbers down and reach, a mutually agreeable amount. If that doesn't work, you may have to contest the violations, which would likely involve wage and hour bringing in the solicitor's office. That's where, I used to sit when I was a lawyer at the department. They'll have folks in the Fair Labor Standards Division of the solicitor's office, or the regional, more likely if you're at the trial level, a regional office, wherever you're located, come in and, work with you and potentially your counsel to negotiate settlement if it doesn't get done at that agency wage and hour division level. Or, you go full bore towards litigation because, those other steps have not panned out. No negotiated settlement, and you just don't agree with where wage and hour is coming from. You feel comfortable with your case. You've retained competent counsel, and they're ready to prepare your defenses and go forward with the litigation process. Um, Note that depending on what the substance of the violations are and what the amount of the back wages or penalties due might be, you could see a press release from your case, and it would likely issue before you contested and vindicated, your position. It would come out up front at the time of the violations, and it would suggest what the violations were and the amount, either the amount sort of assessed or even after a settlement. You could wind up with a press release depending again on the importance and amount of the substance and the penalties due. Uh, you know, it's it's just something. It's something that the government, or at least the Department of Labor, does not negotiate. They won't negotiate press. That's been true for as long as I've been there, and I'm well aware it's been in place since before I started in 2008 at the department. That was a long-standing policy not to negotiate press. So they could potentially put out press releases, and Lindsay referred to those as well. You'll see the priorities that are presented in some of those press releases. Overtime calculation is still a big one. Tips are still a big one. Some child labor, and also interestingly, government contracts are still is still a big, seemingly an area where folks are enforcing. Government contracts are a little bit different. We're kind of focused more generally on the Fair Labor Standards Act during this presentation, though the process of the investigation under some of the other statutes that wage and hour enforces would be similar. For example, if you're doing, publicly funded construction under the Davis-Bacon Act, or you're providing services on a government contract under the Service Contract Act, those will be investigated in similar fashion to a Fair Labor Standards Act investigation. But the frameworks, the legal compliance frameworks, are different under those government contract statutes. In fact, they're different between Davis-Bacon and Service Contract Act. So those are things that if you are in that space, you really need to be on top of. Being a government contractor is not something you want to dabble in, and it's definitely got its own compliance hurdles. That is something we also have experience with. So beyond the Fair Labor Standards Act, if you have issues surrounding prevailing wages, fringe benefit payments, those kinds of things, we can certainly help with those as well. And just a reminder again, in addition to back wages, we talked about the potential for civil money penalties. Really make sure you are having a conversation about those so that you don't get caught up, surprised by some sort of potential civil money penalty after you thought, you know, things were resolved from your perspective. So getting into kind of employer best practices for an investigation. And we talked about some of these, but they're important enough to kind of reiterate. You do want to establish the scope of the investigation and again, narrow it to the extent you can, either by providing samples of pay periods over the, 2 or 3 year request period, or, locking in which statutes are at issue, locking in the type of concerns that are there. Is it overtime? Is it minimum wage? Is it something else? Um, Develop that rapport with the investigator by communicating, by being reasonably cooperative and reasonably timely in your responses to requests from the agency. Letting things linger, being radio silent, it's just going to kind of make the investigator likely to be more aggressive, or loop in supervisors, or just kind of distrust that you're being upfront and sharing everything, or working diligently to collaborate. And again, you want to bring this to resolution. So reasonable cooperation and collaboration helps further your goals of getting wage and hour out of your life. Have a plan. If you're subject to the Fair Labor Standards Act, which most are, and a request letter lands or on your desk, or wage and hour shows up at your workplace, know how to respond to that. Know who should get that letter. Know who should be responsible for collecting materials. Know who should be showing the investigator around when they show up at the work site. Know who you're going to contact, your counsel, your wage hour counsel, to help you support you through the investigation, provide their expertise if you're not some entity that has gotten a lot of these requests or been investigated more than once. Hopefully no one's ever had to deal with these things. But if you do, know what you're going to do to respond so that you can promptly, thoroughly, comprehensively do those things. And lastly, train your team on wage hour priorities. Make sure folks know how to respond to these, and make sure they know the general rights of employers and employees in these circumstances, because that will help mitigate the risk up front. And another way to, sort of mitigate or, avoid the potential for investigations, these are some tips that may seem basic, but these are the issues that people get cited for all the time. And so, you want to keep accurate records, confirm that you're calculating that regular rate correctly, as Lindsay alluded to. And there's a Section 7E, exceptions or exclusions from calculation of the regular rate, that list here's what you can exclude. Be familiar with those. Review those job classifications for exemptions and make sure that folks are actually doing what's in their job description. On the ground work is what's going to matter. The title matters less, the label matters less than what people are actually doing. So potentially revisit your job descriptions. If they are stale, they've been around a while, think about whether they really describe the job and justify an exemption. Ensure that your HR folks are educated on federal wage and hour laws and state analogs. There are many, many different wage and hour frameworks in different jurisdictions. And, the Fair Labor Standards Act typically operates as a floor, not, and states are often stricter, not always the case, but often they are. And so consider how you're going to address those state variations. Similar to, the other kind of, we talk about exemption, misclassifying folks as exempt. The other misclassification is independent contractor versus employee, and you want to make sure you're hitting you're hitting the requirements, the criteria. If you're labeling someone as an independent contractor, that you have reasonable justification and documentation of that classification. Respond to compliance mistakes. Don't ostrich things. Don't bury your head in the sand. Make sure you're really getting back to it. That also mitigates damages in a potential investigation. If you say, "Oh, we made a mistake and we underpaid John," here, John, here's the delta in your 2 weeks, and explain why you're giving him that. But it eliminates his damages if he were to to complain to DOL. And lastly, all of these things are kind of subsumed by this, but conduct an internal audit. Get a third party to assist you, competent counsel, or otherwise. And enforcement is not going away. I'll say, the House and the Senate on Tuesday, the 20th, just this week, the House and Senate Appropriations Committees announced a budget that would allocate 3.7 billion in discretionary funding to DOL, including 260 million to the wage and hour division. And that's actually aligned with the last couple fiscal years. And it exceeds what President Trump was looking for. It's about 25 million over the White House proposal. So they're somewhat maintaining enforcement levels, but of course, year over year, that's a little bit of a reduction because the present value this year, the same amount doesn't get you as far. So there are, reductions in enforcement personnel. There are reductions in investigations, or we expect there to be. And there is a turn towards compliance assistance through these materials, like the press releases, like the opinion letters, like available trainings and other employee or stakeholder engagement efforts. But you know, enforcement again isn't going away. However, if it's reduced, this may give you the time to make sure that your ducks are in a row and that you are, auditing and making sure your practices are current, your policies are compliant. If you've done prior audits, ensure that the recommendations from those audits have been implemented. Otherwise, that could suggest willfulness. You're not complying with problems, you're not fixing problems you've seen in the past. And just make sure that new audit recommendations are also done after you conduct an in-house evaluation. You can certainly involve counsel to protect that audit. Bring the attorney-client privilege to protect that audit, especially where you might find a violation that you need to correct. You don't want to kind of give a roadmap or share a violation necessarily with the department, though they do have a self-reporting mechanism called the PAID program that if anyone has questions about, you can reach out to me. I helped launch it in, I don't know, 2018, I think, but it's back under this administration again. Um, but yeah, I mean, make sure that you're looking at all these things and really also have that system to ensure folks can report internally those issues. As we talked about, it's better to get an internal complaint and address an issue internally than it is to invite wage and hour in because someone didn't know or didn't feel comfortable or wasn't able to report internally, so they have to turn outside and bring wage hour in. So one more sort of really key, we talked about that training and things that you should train on to make sure you're ready for a wage and hour visit or, to address wage and hour concerns. Establish that protocol when you get the appointment letter. Why does that keep moving? When you get the appointment letter or, wage and hour shows up, make sure you know what your response protocols are. Familiarize your managers, particularly HR folks, with wage and hour concepts. Share with key employees that an investigation is happening and identify who takes the lead to coordinate with the agency. Explain what your rights as the employer are, explain what the agency's rights and its investigation are, and communicate to your employees what their wage rights are through training, again, through those mandatory posters, things like that that will demonstrate that you're looking to establish a compliant corporate culture. That about wraps up our substance, but we did want to say this is our first in I believe what will be a quarterly wage and hour piece to that sort of branches off from what you see in front of you here, which is our offerings for 2026 from our L&E group. But we will be releasing that schedule and topics subsequently. So keep an eye out for that. And I think we have a few more resources to share with you on these subsequent slides. I mentioned the employer defense report. You can find again our article up on the letters of interpretation that were recently released by Wage and Hour. You can find them at the top of my LinkedIn profile as well if you want to see that article either on the employer defense report or on LinkedIn. But we have similar blogs that deal with hot topics in OSHA, MSHA, and specific to Cal OSHA, which, as I mentioned, the Fair Labor Standards Act is sort of a wage hour floor, and states differ. California differs regularly, and not only in wage and hour practice, but also Cal OSHA. So if you have OSHA issues, or MSHA issues, we're here for those as well. Um, we also offer special services. These are sort of deeper dives. And Lindsay, I'll let you speak to this one because I know you've presented on a number of these topics.
Yeah, we have a couple of master classes that we offer that, like Scott said, are just sort of a deeper dive into some of the issues that have come up for our clients, some of the ways that we think we can be most effective in supporting our clients. So those are available. And if you'd like any information about those, you can certainly reach out.
Great. Um, So we also have an annual summit in California. Keep an eye out for that. I believe we'll also be having one in the Southeast. I don't want to get over my skis here, but I think information about that, it'll be an inaugural Southeast Summit, in addition to our annual California Summit. Um, we're really good at what we do, as evidenced by all these chamber awards that I won't go through. But speaking of competent counsel throughout, feel free to reach out to us with questions. We didn't unfortunately have time, as we've just gone over by a couple minutes, but if you have questions, certainly connect with Lindsay or myself, or any Con Maciel attorney, and we're happy to address those issues.